Hi everyone, welcome to this special Game Republic webinar on engaging with international markets, featuring leading legal experts Fragomen and finance experts Johnston Carmichael. This webinar will give you tips and pitfalls to avoid when engaging with or as an international remote worker. And I'm pleased to welcome Jane Oberg from Johnston Carmichael and Lawrence Keir-Thomas from Fragomen. So hi, Jane and Lawrence.
Hi, Jamie. Nice to be here. Hi, everyone.
Good stuff. We'll basically have a presentation and then we'll have time for a Q&A. So if you have any questions, please pop them into the Q&A section of Zoom and we'll answer them at the end. A big thanks again to our official partners for supporting our events program. That's Barclays, Red Kite Games and Escape Technology. So I'll now hand over to Jane and Lawrence for the presentation.
Thanks, Jamie. Hi, everyone. So the challenges that the industry are currently experiencing from a talent perspective may now present you with different and new opportunities on a global scale, whether these be as an employer, employee, self-employed contractor. So myself and Lawrence, we're going to go and highlight some of the key considerations from a legal and tax perspective that you should be aware of, and we'll explore from an international opportunity. So as you can see, our agenda seems packed, but what we'll do is we'll signpost the key takeaways for you. So first things first, a couple of introductions. As Jamie said, I'm Jane Oberg. I lead the Global Mobility Department at Johnston Carmichael, and I've been working in global mobility, or international employment taxes might be a better way of thinking about it. I've been doing this for over 20 years. I work with companies who have cross-border workforce, and more predominantly now since the pandemic, more what we call international remote workers. So I work with them, help them identify employer, employee, tax, social security obligations from having a cross-border workforce. So yeah, over to you, Lawrence.
Thanks, Jane, and thanks, Jamie. Good afternoon, everybody. My name's Lawrence, and I am a UK qualified solicitor and a senior manager at Fragomen. I've been specialising in immigration law for 15 years, and I've been with Fragomen for 8 years now. As I say, I'm a senior manager, and in my role, I have two main aspects. Firstly, I manage a team of around 20 lawyers to handle UK inbound immigration work. So my team works with over 30 game studios to assist them with UK immigration matters, ranging from securing work visas for their staff through to sponsor license matters and right to work compliance in the UK. Alongside that role, I also act as the immigration program manager for several large game studios. That means that I work across jurisdictions in both Europe and APAC. I work with our specialist country-specific case teams to deliver a unified service to our clients who are already engaging internationally. So to give you an example, I'm currently working with one client to set up a rapid pre-hire assessment for immigration purposes for their recruitment team in Sweden, Germany, and Spain, so that their recruiters can find out as quickly as possible whether somebody's going to be hireable in that jurisdiction. And then with another client, I'm rolling out our right to work tool for UK right to work checks. So that's me. Thanks, Jane.
Okay. So before we get into the nitty gritty of what we call this checklist bingo card, as you can appreciate, the way of working has changed considerably, particularly since the pandemic, with remote working now becoming more commonplace, with more opportunities for international remote working, both driven by the individual employee, but driven by whether they don't want to be office-based 100% of the time for whatever reason, but also employers are becoming more and more comfortable and open to engaging with individuals who are physically located, not necessarily in the same jurisdiction as the employing entity. So although these types of working are now becoming more common, they do present some complexities for both the individual and the employer. And when we talk to clients about such opportunities, we tend to work through this mental checklist that you can see on the screen. And it can be applied to any scenario of an international remote worker, although the results and the outcomes may be slightly different dependent upon the country combination and the individual circumstances of the particular employee or individual concerned. So I think first and foremost, in the top left-hand corner of that checklist would always be my priority go-to of immigration, Lawrence. So again, I'm going to get this one back over to you for you to talk about a bit more.
Thanks, Jane. So yeah, as Jane said, when you're dealing with an international workforce, be it remote workers or indeed anyone relocating to another country, it's absolutely critical to make sure that your employee has the right immigration permission in place for that country. And failing to do that leaves the business open to some very serious risks. These can include financial penalties. So nearly all countries have some version of a fine or civil penalty applicable for failing to follow immigration formalities. To give you an example, in the UK, it actually went up last week. The fine in the UK, if you hire somebody who doesn't have the right to work and you don't do the right checks, is up to £60,000 per employee. Which is, sizable for any business. In addition to the financial penalties, failing to comply with immigration requirements can also bring about reputational damage. So again, many jurisdictions actually publicize the enforcement action they take against businesses for immigration failings. So, for example, in Germany, they have a visa alert database, which publicizes the details of all organizations guilty of immigration offences. And we see other examples that look very similar. And then, in addition to the financial penalties and the reputational damage, the future potential for hiring foreign nationals can also be impacted as well. So you often see compliance failures impacting the ability to hire foreign nationals in the future. So taking another example in Sweden, if you have an employer who isn't compliant with immigration formalities, then they might lose their certified status with the migration board and then be potentially banned from hiring foreign nationals in any different capacity for a fixed period thereafter. So that's why it's really, really important to pay attention to immigration and make sure you get it right. So what do you need to know about that when you're dealing with international remote workers? Well, broadly speaking, there are traditionally two types of immigration permission that relate to work. But increasingly, we are seeing a third option as countries roll out remote worker programs. Those two options that I mentioned, the first one is for business travelers or visitors. The terminology changes per jurisdiction. Typically, that's the immigration permission that would be appropriate for somebody who was on a short-term trip into another country. What we mean by short-term will again vary by jurisdiction, but as a rule of thumb, you might be looking at between 1 and 3 months. So there's limits on duration, and then separately from that, there are significant limits on what work can be undertaken when somebody's in a country as a visitor. This is the business-related activities. There will always be some provisions for business-related activities for visitors, but there are often fairly strict prohibitions on doing much productive work for any length of time. So that's your first category. Second to that, you would then have work authorization. So that would be a work visa or work permit, depending on the country you're in. That would be for longer periods of work. So if you are hiring someone as an international remote worker, and it was going to be a longer term role, then you would be looking most likely at a work authorization situation. And that's typically for highly skilled roles. But the main barrier for international remote workers is that it will often require sponsorship from some sort of local legal entity from your business to be able to secure work authorization. So it does often mean you need to have an established entity in order to secure that. The benefit to work authorizations are that it was for longer term, as I say, typically 3 to 5 years, and will often lead to permanent residence. But bear in mind, you will also have to factor in government fees, which will vary significantly from jurisdiction to jurisdiction. Again, to give you an example, if you want to secure a work permit or visa in Germany, you're looking at approximately 300 euros, whereas the equivalent of that in the UK would be north of £6,000. So that's your two traditional types. visitors versus work authorization. As I mentioned, we're increasingly seeing the rollout from different countries of an actual specific work permit that's available for digital nomads or remote workers. Now, of course, remote work's not a novel concept, but it doesn't traditionally fit into those, or doesn't fit into those traditional models of work authorization or visitors. Either it's too short term or you need to have a legal establishment. But we are seeing increasing numbers of countries roll out post-pandemic a specific visa for those purposes. Now, the premise of the big benefit and the premise of these programs is that they more often than not will not require you to have an actually established legal entity in the country, which is an enormous advantage, meaning that you would be available to opening up to additional talent in those jurisdictions. For all that they are positive developments, they are still at early stages, and there is only there's only around 7 or 8 countries in Europe that offer them at the moment. The most popular being Greece, Portugal, and Estonia. So it's still very much a work in progress, and with each one that gets rolled out, you have to understand there are going to be unique requirements as well. So yeah, those are the key kind of types of work permission to be available, to be aware of. In addition, you will have to consider factors around the individual's nationality. For example, if you are dealing with someone who's an EU national working in another EU national state in a member state, then you're golden. You're not going to need a work permit. As I've already alluded to, length of stay is going to be relevant. If you're going to hiring someone as a remote worker for a very short period, it may be that they could do that as a visitor, but if it's for longer, it may be needing one of these remote worker visas or needing work authorization. And then lastly, the proposed activities that the individual is going to be doing. Again, that will determine whether somebody can do it as a visitor, will require work authorization, and then again, the destination country if there's available to have one of these remote worker visas. So back to you, Jane.
Thanks, Lawrence. So yeah, so moving on to the tax considerations that we need to think about as an employer when you're engaging with someone who is considered an international remote worker, or think about it as if you're an employer who doesn't have an entity in the jurisdiction where that individual is physically located. There are a few things to bear in mind, and there's just a few highlights that I wanted to pull out at a really high level to make you aware if you ever find yourself in this situation. So the corporate permanent establishment point, so the middle one on that top row, is at the corporate level, do the activities that that individual is going to be undertaking present a risk of creating a corporate taxable presence of the UK company in that overseas location? And as you'll probably be more than familiar, or you will at least be by the end of this presentation, is that every country has different rules, regulations, and thresholds applicable to everything that we're going to talk about. So it's really difficult to say, give you an exact science of an answer. It's just raising the awareness. But in some countries, the factors, or most countries, the factors that are taken into consideration when looking at corporate taxable presence are the activities that the individual is undertaking, the seniority of that individual. Do you, as an employer, have a workspace, an office space available to you in that location? And does the individual have the ability to negotiate and conclude contracts on behalf of the UK employer? These kind of exposures and risks apply equally to employees and self-employed contractors. So it's something, if you are going to engage with an individual overseas, it's something just to be aware of, and just to have that review and comfort, whether you know that there's a taxable presence created, or whether you're absolutely certain that for that particular instance, there's no risk for you as a UK studio. So it is moving on to the next one, that employer payroll obligations. So as an employer, you may have an obligation to operate a payroll, even if you're in a situation where you're a UK entity, you don't have a corporate taxable presence, you don't have an office, you have one individual sat behind a computer working from their home office. There still may be an obligation for you as a foreign employer to register and operate a payroll and calculate payroll withholding taxes for that individual. And you'll see the theme that I'm going to tread throughout this presentation is that each country has, again, its different rules, regulations, and thresholds on this. And some countries may determine that it's whether they have a permanent corporate establishment. Others may determine the length of time in jurisdiction for that individual. So it's just to be aware of that, even if you don't have any physical presence in that location, you may still have an obligation to operate payroll withholding taxes. And that kind of goes hand in hand with social security. Social security, or national insurance, as we call it here in the UK, again, different rules for tax, and typically payable in one location, and typically payable where an individual works. So you may, again, building on what we've just talked about, be in a situation where you're a UK employer studio, you have an individual in an overseas location, you don't have a corporate permanent establishment, you have one individual working from their home behind a laptop, you don't have an obligation to operate payroll, but you do have this social security liability that needs to be paid at the employer and employee level in that overseas location. And how are you going to facilitate payment of that? There are different ways to facilitate payment depending on the different jurisdiction, but the most common way of doing that is registering as a foreign employer and operating a payroll for social security purposes. So even though you can presence, employer payroll, you may still have to register as a foreign employer to look after that social security obligation.
Sorry, Jane, you cut out a little bit in that last bit. Could you just repeat that about the social?
Was it on the building blocks bit?
Yeah, just the last sort of minute of stuff.
Yeah, sorry. So you may find that you're in a situation, building up on what we've talked about before, that you don't have a corporate permanent establishment, you don't have an obligation to operate payroll, but you may still, as a UK studio hiring someone overseas, have an obligation to calculate and pay across social security at the employer level and the employee level. And the way to do that, in most cases, not all cases, but in most cases, is to register as a foreign employer and operate a payroll for social security purposes. So you could find you're not ticking all the boxes for the three things that we've talked about before, but the social security point will get you into the place where you need to register as a foreign employer to pay the social security across. So it may not seem a big risk or a big area and priority, but it's an individual social security, it's an employer social security. It's just one thing to be aware of, because that can trip you up inadvertently. And I think, handing back to Lawrence, that tees up nicely the EU posted worker bit that we just wanted to draw out as well.
Thanks, Jane. Hopefully what is coming across from the session so far is that there's a lot of common themes in these different areas for consideration, and they are increasingly becoming interlinked in practice as well. And one area where that plays out very tangibly is around EU posted worker notifications. So for background, the Posted Worker Directive applies to all 27 EU member states, as well as the members of the European Economic Area, so you're Iceland, Liechtenstein, and Norway, and to Switzerland as well. And they're an additional consideration on top of immigration, and they are it's a marrying up of immigration and social security and employment law, in that basically any company that is sending or employing someone for a temporary period within the EU, regardless of that person's nationality, will potentially have to make a notification to the government authorities in that country about what work and, crucially, what salary that person's being paid for in that country. The idea behind the directive was to make sure that there was sort of not undercutting terms of terms in different of employment in different jurisdictions by stealth, so that essentially you have to, employers who are sending their staff into other EU countries have to keep a record and share that with the relevant authorities. So as I say, that's the theme of posted workers. The reality is very much akin to what Jane was just saying, which is that each country has their own requirements. So although this is an EU-wide directive, it's been interpreted and implemented slightly differently by all 27 plus 4 members of the EU, which again presents some significant challenges for businesses looking to remain compliant. I give you a practical example of that. The time threshold, whether you need to make a posted work notification, will differ from different countries. So in Spain, if somebody is, the threshold for triggering a notification is 8 calendar days, whereas in Sweden it's from day one. It's the same directive, but that's how they've chosen to interpret it. And failing to file the required notification again has quite similar consequences to failing to adhere to the immigration requirements that you find. So it could be a financial penalty, and that varies wildly in amount by jurisdiction. So in some countries it's as low as €70 for a first time violation, and then in the most serious cases it can go up to €225,000 for repeat offenders or egregious circumstances. So again, failing to complete your required EU posted work notification will have financial penalties. It will also potentially involve negative publicity. In the same way as immigration compliance failures are publicised, you will often find that there will be publicity around any enforcement action taken on posted work notifications as well. And again, it can also, in certain circumstances in certain countries, lead to the suspension of the ability to sponsor or employ foreign nationals as well. What can you do about it, I guess? And that's luckily that's why Fragomen and our colleagues exist, is that we have designed various tools that our clients use in relation to both EU posted worker and immigration compliance. We have a tool that will do automated assessments for you to decide whether or not you need to even file a posted worker notification, or whether somebody will need work authorization, or whether they can complete their work as a visitor, or whether they can do it as a remote worker. And then in many cases it will go on, and has automated the process of actually applying for the relevant immigration permission where that's possible, or filing the relevant posted worker notification again where that becomes necessary. And we also do a lot of work with our clients around managing this risk as well. So as I say, you've got 27 different possible ways it's being interpreted, and we'll often do a risk matrix alongside our automated tool to give both the full legal compliant version versus what's a business sensible solution as well. So yeah, that's really kind of the key facts from an immigration and an EU posted work and side of things, I'd say. So back to you, Jane, for finishes up with employment law.
Yeah, thanks, Lawrence. And I know I've talked primarily about tax and social security exposure and obligations, etc. But one of the things that we always say to our clients when we're working with them in such situations is, even though Johnston Carmichael don't provide the employment law services, we would always recommend that you have an employment lawyer review any employment contracts you have in such circumstances of international remote workers. And the reason we say that is because there may be some mandatory benefits that have to be provided in that overseas location as UK employers we just wouldn't be aware of. On the converse, UK has auto-enrolment provisions for pension contributions. Overseas locations may have some similar provisions that we would need to be aware of and include in that employment contract. Equally, if you're using the UK employment contract as a template, that's fine. However, if you do offer an employment-based pension scheme, it's worthwhile checking with your pension provider that they can accept or will accept contributions from an overseas employee, because sometimes that isn't always the case. So as an employer, you need to think about, well, can we do this? If we can't, are there any alternatives that we need to provide in lieu of that? Or is there something in that overseas location that has to be provided instead of that UK pension scheme, for example? So I think this slide encompasses what we've talked about, Lawrence, in terms of it will serve as a really great reminder for you if you're in this situation. It won't give you all of the answers, but you'll be able to go through the checklist and go, have I thought about this? Have I thought about this? What do I need to do on this? And it would be remiss of me not to mention a couple of other alternative options for UK employers who are engaging with international remote workers. This has been primarily focused on the employer-employee arrangement, but we work with a number of different game studios studios who have international remote workers and who've been through this exercise and through this checklist, and other options available to them and to you would be going down the route of a self-employed contractor. If you don't want to engage somebody overseas as an employee, can you do that as a self-employed contractor? And it might firstly appear that your employer obligations would be removed because you have this self-employed individual, they're not an employee. However, I would just urge caution on that in terms of we may see them in the UK as a self-employed contractor, but that overseas jurisdiction may not necessarily view them in the same way. They may look through that arrangement and actually see that as an employer-employee arrangement. Equally, the exposure and risks and things we talked about in that corporate permanent establishment piece would still apply if you're engaging with an individual as a self-employed contractor. So it doesn't necessarily remove all the exposure or the risk. It's just another option available to you if you're going down this route. And then the final one I just wanted to mention, you may have come across the terminology of an employer of record company. So they have seen a significant growth in this area, primarily due to the pandemic, primarily due to remote workers, and are a really good tool and a potential option for companies who are starting out on their international journey, their expansion journey, who don't necessarily have an entity in that overseas location where they want to hire an individual. The employer of record takes on the legal employment of that individual. So they will look after your payroll obligations, your social security obligations, your employment contract obligations. But you, as in this example, the UK studio as the end user, would still need to consider the corporate permanent establishment risk. So they take away some of the obligations for a fee. They won't take away all of the risk. But as a short-term fix before you decide what you want to do in that overseas location, it's certainly a viable option and one to be considered. So hopefully that's given you a flavour of the things to think about when you're engaging with individuals overseas. And again, take away this checklist and use in any similar situations you come across. So Jamie, I don't know whether there's been any questions, whether you have any questions you want to pose to us.
Yeah, I mean, I'm staggered really at how much there is to take on board with because I would have thought that self-employed contracting would have been quite straightforward. Like if you're employing someone on a contract in Germany or somewhere, they would have been quite straightforward, and you wouldn't have to worry about employment law and things like that. But from what you're saying is that you still have to be concerned if you're just a small studio and you're contracting with somebody in Germany, then you just have to be wary of being caught up in some of the legislation. Is that right?
I think that's right, and I think it's that being wary of it and being aware of it. There may not be any particular obligations that you need to do, but I would certainly have it in the back of your mind just to have a sense check of whether if you're engaging with somebody in Germany, is there anything from an employment law that I'm missing that I need to include? And again, as Lawrence has alluded to before, it's not always the financial recompense or financial consequences. Sometimes, and more importantly at this stage, it's your reputational damage or reputational risk that comes into play. So if you're a UK studio wanting to employ an individual in Germany, I would absolutely have a sense check on the employment law. If you're a UK studio looking to engage with a self-employed contractor in Germany, again, I would just sense check from a tax lawyer's perspective, is that can an individual be self-employed in Germany with an overseas end user, an overseas client? Is there anything that they need to be aware of, or does it bring the studio into some kind of obligation in Germany? It's just having that, it's having an awareness that you need to think about it. From a commercial point of view, you might be comfortable with it being at the bottom of the priority list and you're comfortable with that risk. That's for an internal risk discussion, but being aware of it is what I would suggest, really.
I mean, I imagine with contracting and things, you with self-employed contractors, you'll have a contract which will handle things like IP and make sure that anything that they're creating belongs to the company. But I mean, would like with Fragomen, would you be able to include, you know, a contract that would include things like, you know, employment law in that particular country? Would you handle that in the contract?
Thanks, Jamie. Yeah, look, not necessarily employment law from our point of view, but you can put in terms around kind of expectations on that person, making sure they can have their immigration compliant as well.
And that
So
they're paying social security in that country and things like that.
Yeah, it's the reason why this becomes so important is and why it's more important than it's ever been is what's happened in the last few years is an enormous uptick in information sharing between different agencies. So
Right.
that's why why Jane actually, this is why we have this sort of checklist type approach, because historically you could quite easily rely on an immigration authority having absolutely no idea what was going on in a tax or social security point of view, and you would therefore not have to worry about it. But now in all of the countries we've been talking, we've mentioned, in Europe particularly, there's an enormous push for information sharing. So and it happens in the UK as well. So now the UKVI actually works really closely with HMRC to check people's tax records to make sure that they're compliant, that they're not working illegally. It's their number one way of catching people illegally working. And then, for example, in Germany, the immigration agency now talks far more to the labour enforcement than ever it did before. And again, that's happening on a national basis and then an international basis as well now. So there's cross-border sharing of information, which is why you can end up having to think about these things more than you've ever had to before. But it's not about, and again, it's not about becoming an expert in any of these areas. It's simply about just knowing that this is something to be aware of, and then there are, as you might expect, we might say there are folks out there like myself and Jane whose job it is to simplify that for you.
Yeah, I would definitely be calling on you, I think. Trusting myself to do this sort of stuff. So one of the questions that I had written down was, that how will the authorities ever know that I've got employees based overseas? But it's that thing that you were saying about that they talk to each other, the agencies talk to each other. What about the cost? Because I was staggered again. Like Germany charged €300 for a visa, and we charge £6,000. Is that right?
Yeah, that's right.
Good grief.
The UK
Brexit dividends. There you go. There's a
yeah,
Brexit
it's
bonus.
I'm actually currently doing a little bit of work on some international comparisons for this for the industry, and it's one of the big competitive disadvantages in the UK is we have pretty much the highest level of government fees that are around globally. It's always going to be thousands and thousands of pounds. There are other advantages to it, the UK, in that the system works probably more effectively and efficiently than most other jurisdictions, but you'd hope so for the price you're paying. But yeah, there are big variations in costs for immigration at the upfront costs that are borne by the employer, and typically within the EU, they're always going to be a lot lower, partly because those countries will charge them lower, and partly because of EU-wide schemes as well. So there's a scheme called the EU Blue Card, which is for foreign nationals who are highly qualified to work in different, can work in most European states, and the cost for that is always only in the hundreds of euros, whereas in the UK,
the extra costs, if you were getting someone else, in olden days, when we're in the EU, you would have had to do all this stuff for international people outside of the EU. But now, because we've left the EU, we have to do this. Because I remember employing someone from the EU, when we were in the EU, and it was dead easy. We just sort of got them across from Ireland, we got them on the payroll, job done. There was no, nothing. So this is all because we're now not even in the economic area.
Yeah, precisely, Jamie. Yeah. So from a UK perspective, that's been one of the biggest hits that we've seen for the industry, has been exactly that. Is that there's when you look at the UK surveys, like the EU national population within the industry is huge. It's far bigger than in most industries.
I think it's about 30% or something.
Yeah, which was probably one of the highest, if not the highest, I would say, in different industries. And yes, folks there who would historically you'd literally just need to see their passport, and from immigration perspective, you were done. Brilliant. That's all changed now. They are EU nationals now treated no more favourably than US nationals, Indian nationals, where you're going to have to go through the rigmarole of getting the right immigration permission.
No, very, very interesting. I'm aware that I'm sort of asking all the questions and banging on about Brexit as I usually do. But if anybody has any questions, please do. We've got about 5 minutes left. So if you've got any particular questions, that relate directly to your company, this is a good opportunity to kind of get in there and ask a quick question. So please do so. Quick one about sort of immigration work permit documentation when traveling in EU countries covered by Schengen rules. Is it the same kind of situation? Does it make a difference, or is it not? It's not.
Schengen is all about convenience, to be honest. So Schengen is a form of visitor visa. So I talked about visitor visas and work authorization. So
there's
Schengen
1 to 3
is
months and things.
Yeah, so there's some Schengen is really useful because it applies some universality between countries. So and like I say, it means that you don't have to go through border checks for countries in the Schengen area. So if you get a Schengen visitor visa, you can basically go to all the different Schengen countries. But overall, you're still limited to 90 days and 180 days, and to only certain business activities, which do vary slightly, even between countries. So yeah.
So if you're doing a conference, you could obviously use that. But if you're coming to do like work programming for 3 months, would that be different?
That would be probably then that wouldn't be appropriate to use the Schengen for. Okay. So yeah, again, that's the sort of thing. Look, that's the sort of thing that our very handy nomadic tool will calculate for you. I'm glad, because we used to do it all on a manual basis, so it's very nice to have that available.
And that's on your site, is it?
Yeah, we have it. It's our platform. It's called Nomadic that we have, and I'll share the link for you to distribute to attendees afterwards, if Jamie. We can.
If you can bob it into the chat as well.
Actually, I'll pop that in there so folks can see that. But yeah, that's it's basically that you have to consider those factors to length of time. But yeah, Schengen is all about it's effectively a type of visitor. Yeah.
And Jane, this thing about sort of paying tax and social security, is it usually the case where as long as you're paying tax in one of the countries that you're fine? Is it just when you straddle both of them that there's an issue? Is that?
Yeah, I think it can become more complex and struggling, particularly when you've got an employer in one location and an employee in the other. So if the individual is based in one location, say Germany, for example, and they're living and working there, they would pay their taxes there. Whether the employer has to operate the payroll, different, but yes, they will pay their taxes. If that individual comes to the UK, if they've got a UK employer, they come to the UK, then the UK employer then needs to think about the pay-as-you-earn obligation, and the individual may also have that liability in both locations. Initially, there is tax treaties to mitigate double taxation, so there won't be a situation of double taxation. It'll be a case of monitoring, managing it, and mitigating it so that you've got the right slice of tax in the right country. So everybody wants a slice of the pie.
I see. Right. Okay. I'm just looking at Lawrence. I think I'll post this in the chat to everyone, so everyone can see. That's the link to your tool that allow people to kind of play with that a little bit. I think Dan, you wanted to ask a question, but I think through this, how we've got it set up, we can't sort of get you on the screen. Can you bob your question into the Q&A, and then we can sort of quickly answer it. We've got a couple of minutes left. If people want to get in touch with you, Lawrence and Jane, have you got your emails as well? Is there a good way of getting in touch with you?
If the slides are going to be shared, I think I put them on the end slide.
Right.
Cool. Our email address is on there. Otherwise, I can put it in. The.
They were on the slides, which I've then stopped sharing. So.
I know it's.
It's good. It's all plans, all exactly what we wanted to happen. Yeah, good stuff. There we are. Yeah, just bob them in the. I'll.
I don't know whether I can send it to everybody.
Yeah, I've put it into to everyone. That's Jane's email there.
I'll just put yours in.
Cool. Hey Dan, here we are. Thanks, Jamie. Great webinar. Is it easier to hire from the US or the EU?
That's a loaded question.
From a UK company perspective, is Dan's sort of.
That's a really good question. If you want to hire them to relocate to the UK, it might be marginally easier from the US, because one of the requirements is an English language requirement, which you can which is exempted if you're from the US.
It's easier from the US. It's just.
It's true. Yes, so now it would be marginally easier, but overall the requirements are more or less the same if you're looking to relocate someone to the UK. If you're looking into remote work, it's a different kettle of fish. You have other considerations in North America. You don't have to think about EU posted workers, but you have to think about a whole bunch of other stuff as well. And when you're thinking about kind of state, you're thinking by state requirements as well as federal requirements in the US as well.
Yeah,
I'll put that as part 2 of the webinar.
Good grief. Yeah, well, unfortunately, I think we've run out of time today because we said we'd have 40 minutes. But that's been really interesting and useful for me as well. I mean, really fascinating stuff there. I never realised what was involved really. So if anybody watching would need more information, I've given you Lawrence and Jane's emails there. You can contact them directly. We're recording this as well, so I'll make sure that everyone gets a copy of the recording. But thanks again today to Jane O'Berg from Johnston Carmichael and Lawrence Keir Thomas from Fragomen. That's been brilliant. Thank you.
Thanks, Jamie.
Thanks
Everyone. Thanks, Lawrence.
Cheers, everyone. Thanks.
Excellent.
Cheers,
our next Game Republic event is New Partners and PR on the 18th of April in Manchester. And we've just launched our Great Northern Games Discord. So you can easily stay in touch with us and hundreds of other devs across Yorkshire and the North. So check your emails from Game Republic for details, or just get in touch with me, Jamie at gamerepublic.net, and I'll give you the link for that as well. A quick note about Gamayo on the 23rd of May, hosted and sponsored by Taliad North as well. If you have a game to demo, please register for Gamayo as soon as you can, as there are only 7 demo places left out of those 20. So we're already filling up with brilliant games. So if you want to show off a game on the 23rd of May at Taliad, sign up immediately. That's it. Big thanks again to our official partners, Barclays, Red Kite Games and Escape Technology. And thanks everyone for watching today. Brilliant. And see you again soon. Cheers.
Take care.
Thanks.
Bye everyone. Bye.